Let me thank my friend Professor Mohan Gopal and also Vidyut for organizing this. Perhaps this is the first seminar, whether live or online, on the question of judiciary and the oppressed castes. I would use oppressed castes, Dalit Bahujans, because they are really oppressed in legal terms also. Now, the Indian judiciary, as of now, by and large is anti-Dalit, anti-Shudra, anti-Adivasi. It has a very nuanced relationship to religious minorities, because the religious minorities are global, whether it is Muslims or Christians. What happens to them is also heard at the global level. But what the judiciary does to Adivasi, and the backward classes and the Shudras in a larger sense, whether it is in the recruitment, whether it is in terms of evolving a judicial processes and relating it to the question of morality, ethics, democracy, justice. So there has been a consistent opposition to the productive communities' life and participation, development, liberation, wherever it was required. The reason, in my view, does not lie in constitution. Constitution is basically a legal system. But the reason lies in the large amount of judicial personnel who come from basically Dvija communities, who have a long-standing childhood training that the Dalit, Adivasi, Shudras are worthless people. Their culture, their need in the larger governance, participation in education, in employment, in overall development is not a divinely accepted notion. Now, this has gone into, by and large, the minds of large number of lawyers, right from their childhood and then in the training of the universities, and the lawyers become judges. So therefore, there is a set thinking that the productive communities have no abilities to engage with the national issues, the equality questions, and they should be in the production zone if they are cattle rearers, if they are tillers, if they are fishing, if they are, as Bezawada Wilson is dealing with, scavenging, or any productive work. But the Dvijas in India have never participated in production, and they think it is right. You must understand this because judiciary, whether it is lawyers or judges, are very religious people. If you see them around temples, festivals, the way they conduct themselves, they are very religious. There's nothing wrong in being religious. But they are religious in the sense of Varnadharma. in the sense of historical evolution of the Vedic law that they know, the epic law that they know, they consider them as laws. Vedic texts they consider as legal, epics they consider as legally valid, therefore they keep quoting from epics. You know, I remember as a student of political science, we were taught the Shanti Parva as great political theory in Mahabharata. And then Kautilya and Manu are central to them in their understanding of law and state. Once they prioritize Vedic thought, Upanishadic thought, Kautilya and Manu, then the constitution becomes a secondary instrument of legal interpretation. Now, I've been reading a lot. You know, I and Mohan Gopal for quite a long time have been interacting. Reading a lot about even the best of liberals, even the communist background lawyers, judges, demanding for constitutional morality, both from judges and lawyers. But the point is, all over the world, constitutional morality is a later evolutionary morality. Now, what is the primary morality is the spiritual morality of people, because most people are religious. And we know what happened in US. Trump appointed a judge which is spiritually conservative and pro-life at a time. And though these judges in US, Supreme Court judges get grilled by the Senate, in India there is nothing like that. Judges appoint judges and lawyers become judges. Government intervenes in a way that it can and sees that its own people get. Now that is where we see some difference in the judges appointed during Congress period and where the communist parties were ruling and now when the BJP is ruling. So therefore my fundamental premise is in all our schools and legal training colleges and institutions, spiritual morality is still varnadharmic, and there are no large number of Dalit, Bahujan, Adivasi scholars emerging to contest that varnadharmic morality as being interpreted as the right justice. Because the notion of justice has not come from straightaway constitutions. If anybody thinks that constitutional discourses, the first ever constitution written in the world was that of American Constitution based on the evolutionary legal thought of Europe, particularly John Locke and Thomas Paine and so on. Constitutional morality came from the spiritual morality. Now, I have a book in my hand. This is God's Justice. This is a massive book. It examines the whole notion of justice that emerged from the idea of God. Now, the central idea of God's justice evolved in Israel through a long period of discourse, and justice, the idea of nation, the idea of citizen, and the idea of notion of equality have roots in this God's justice concept has evolved in. Now, in India, for example, in Hindu religion, there is no idea of God's justice. I have not read anything about the idea of God's justice. So, for example, the fundamental idea of God's justice starts with the assumption that God created all human beings equal. Now, I would like to know from Mohan Gopal, who has involved in training lawyers and judges and has been interacting with Supreme Court judges, several High Court judges. Do they think that Hindu God created all Hindus equal? Is there such idea among them? If the judges of Supreme Court, High Courts, the lawyers think that the Hindu God created all Hindus equal, then there is no place for caste. Then there is no place for untouchability. When the lawyer is arguing on behalf of the clients, if the client is a Dalit, if the client is Adivasi, and if the lawyers are not their own community lawyers, if they appoint a Brahmin, Banya, Kayastha, Khatri, or a Kshatriya, or even Shashi Tharoor kind of a Shudra lawyer, then I picked up Shashi Tharoor's name because he wrote a book called Why I Am a Hindu, without writing a word about caste, and justifies everything that is happening in the name of Hinduism. I picked his name not because I'm personally against him, because he's writing these days. So if these people don't have the idea of God creating all human beings equal, then how do they deliver? How do they represent their clients? If you appoint a Brahmin lawyer to argue, then a Dalit, a Adivasi, an OBC, if we appoint lawyers to represent Brahmin, Banya, Kayastha, Khatris to argue reservation cases, what do? How do they present it? Then how do the judges listen it? See, in scholarship, there is what is known as the method of reading a text and understanding a text. How do you read a text and how do you understand it? In legal system, there is a method of arguing and there is a method of listening by judge. And the judges make those points and then deliver their judgments. Both in arguments and listening, if it is a varnadharmic, then what kind of judgment will come out? So my idea is you need to think of deep Brahmanized legal training. There is a book written by a friend of mine, Brajaranjan Mani, De-Brahmanizing History. Is there any book written by any lawyer that de-Varnadharmizing legal structure or de-Brahmanizing it? Is there anything like that? If there is nothing like that, what happens is, even I went to several law colleges, including the Bangalore National Law School, to give talks when Professor Mohan Gopal himself was the Vice Chancellor of that. 90% of the law students there were anti-reservationists without understanding, and very violently. They were not allowing me to speak. This is also true in the civil service. I spoke to very senior IAS, IPS officers. They said, no, we don't want to hear about anti-caste discourse. How can you counterpose Ambedkar to Gandhi? If you want to talk, you just praise both of them. Now, this is the kind of civil service, the legal student fraternity, and the faculty. I hardly found a Shudra, leave alone OBC, Dalit, Adivasi, top faculty member in national law schools, who has the courage and confidence to take on the reality of Indian social system and put, there is a village law. After all, what is law? What is judgment? What is judiciary? It deals with people's problems. Maybe a marriage, maybe a land dispute, maybe a murder, but these are resolved at village level in a much more with positive divine justice than what is happening in established courts of the Constitution. So to me, the constitutional morality argument is a very weak argument without foregrounding it on divine morality, on individual ethical morality. See, if law does not deal with individualism, then law naturally deals with groups as castes. So what Brahmins do will be right. For example, on the beef and vegetarianism issue. Beef was a very lynched agenda issue now. Now, how do judges deal with beef question if all of them are pure vegetarian who think that meat food itself is pollution, which is taught in sociology, which is accepted in legal discourses? Now, see, I wrote this book called Buffalo Nationalism, and I asked two former Supreme Court judges in 2001 when we were taking the caste system to UN in Durban, Justice Verma and Justice Ranganath Misra, I think. They were saying that why should you take untouchability and caste to UN? We can resolve here. Now, then how are you comparing caste question to race question? I said, see, I was deposing before them. Now, in our constitution, there is a protection to cow. And mostly Indian cow is portrayed as white animal. Now, why there is no protection to buffalo? And buffalo is a black animal. Therefore, there is no protection, even though it gives the same milk and in more quantity. Then I asked Justice Verma, who was supposed to be a very progressive judge, that suppose if a buffalo was to walk into your Supreme Court when you were Chief Justice and demand equal right with cow, what would you have done? Perhaps you would have dismissed all the watch and ward staff there and asked them to wash the Supreme Court with milk. Now, if that is the attitude of, or that is the blindness of a Supreme Court about animals, animal equality, that too in the Constitution, it is natural that they will also look at this as caste inequality. It is from this point of view, I would say every legal college must talk about God's justice, individualism, not collective casteism, and equality and morality. Constitutional morality is, to me, very inadequate morality because Constitution basically does not deal with moral questions. It deals with legal questions. Now, without a moral dimension to lawyer and judge, there is no question of they can go to Tirupati today and then give a lot of money there and then make more money in the courts by robbing Dalit, Adivasi, Shudra or women clients without any sense of guilt. So if the legal system is guilt, there is a saying, lawyer is one who tells lies, lawyer is one who sucks money, lawyer is one who by hook or crook manages a judgment in his favor without any morals. Now this morality comes from what I call God's justice, not human. If there is no fear of God also, there is no fear of anything. There is no fear of constitution, fear of law, because the castes are organized for themselves. If we are dealing with this kind of a massive system of 3,500 years, we need to undo this. So this is what the problem in my view. Thank you very much.